Jennifer McCabe was on the stand the entire day yesterday. Her testimony is going to continue tomorrow on Friday. Today, Thursday, is an off day, so there is no trial today in Karen Reed's case. Now, there's about another hour and a half left of the cross-examination for Jennifer McCabe. Then there's going to be some redirect by Hank Brennan, maybe some more recross, and then they're going to move on to other witnesses. Now, Jennifer McCabe's testimony is incredibly crucial for the Commonwealth's case. After all, she is one of the few people that overheard Karen Reed admitting to this crime. She said to an EMT, at least Jennifer McCabe's testimony was that she overheard Karen Reed telling an EMT, I hit him, I hit him, I hit him. It wasn't in a question form. It was an affirmative statement. I hit him, I hit him, I hit him. So that was Jennifer McCabe's testimony, and now you can understand why it's so important to the Commonwealth's case. Well, Alan Jackson performed cross-examination yesterday, and we're going to be going through some of the highlights that I think were the best parts of his cross-examination. Now, I do want to make a mention that Jennifer McCabe's demeanor this time was a lot better than the first trial. She was much more calm, much more soft, much more portraying this just ordinary soccer mom who got swept up into this ordeal, which she had no interest in being part of. And this is a close friend of hers. So she's definitely coming across a lot better this time with her testimony than she did, I think, in the first trial. So definitely some points for her. But Alan Jackson is Alan Jackson. So he was definitely also able to get some points on cross-examination. And that's what we're going to be going through today to show you how Alan Jackson is actually a very effective and very good lawyer. So we'll take apart some of his highlights of the cross-examination, and obviously I'll give you some of my commentary as we're doing that. So here we go. This is the first part. The first part that I want to play is the part where Jennifer McCabe's talking about how this other law enforcement agency, which we all know to be from the federal government, came in and was asking her questions. And there was a 10-minute period of time where she needed to get ready before they came in to ask her questions. And during those 10 minutes, she made a few phone calls. She made a phone call to Matt McCabe, her husband, to come home. And she also called Carrie Roberts. And then we're going to hear that she actually made some even more phone calls. And that's something that she did not initially tell the agents, but then she eventually called them back and said that she actually also made some additional calls. So first thing that Alan Jackson is going to be focusing on is, why did she feel it necessary to call Carrie Roberts? And something that Alan Jackson is very good at is painting a picture for the jury. It's something that you also find that good lawyers, good trial lawyers are able to do, is that through their cross-examination, they're able to paint this picture for the jury of what's going on, even if that's not technically what's going on, but they're able to pinpoint certain parts of the testimony to argue, at least to the jury, that what's really going on here is that there's a coordination between Jennifer McCabe and Carrie Roberts to make sure that their testimony is in line with each other. So that's something that he spoke about with Carrie Roberts, how Jennifer McCabe was always talking to Carrie Roberts before she spoke to a grand jury or testified. And now he's going to bring out the same points when it comes to Jennifer McCabe talking to Carrie Roberts before she talks to these federal investigators. So let's start with this. And we're also going to see some of the comments that Judge Cannoni made during the cross-examination, which I may have spoken about before, but now we're going to actually see it play out in action. So here we go.
You wanted to find out if she had talked to these particular law enforcement officers and what she had told them, so that your story could somehow align, or it could inform how you responded to questions that they asked you. Isn't that true?
That's not true. We both know what happened. We don't have to have a story. There is no story. There's what happened, and that's it.
So if that's true, Ms. McCabe, you'd have no reason to call Carrie and ask her if she'd been contacted by these law enforcement agents, because it's just the truth, correct?
So his question is, you would have no reason to call Carrie Roberts. Why would you have any reason to call Carrie Roberts? You would have no reason. So what's the question? You would have no reason to call Carrie Roberts if all you're saying is the truth. Just say the truth. What do you have to call Carrie Roberts for? But again, the question was, you would have no reason to call Carrie Roberts, right? So that either gives a yes or a no answer, right? Let's see what she answers.
We're going through this whole experience together. We call each other about everything. That's nothing more than that. I'm sorry.
Let her finish her answer. Go ahead, Ms. McCabe. You can finish that.
There's nothing.
So right away, we're seeing the judge allowing her to give whatever answer she wants. And that's something that I don't find appropriate. I don't think it's proper. I think the whole point of cross-examination is that I get to ask certain questions and you have to answer my questions. You can't answer whatever question you decide. I didn't ask for an explanation. I didn't tell you to tell me the reason why you're calling Carrie Roberts. I said there would be no reason for you to call Carrie Roberts if all you're going to do is say the truth, right? So it's either right or wrong. And then if I want an explanation, I can ask for an explanation. But the answer here for Jennifer McCabe should be, no, wrong. That's not accurate. We also want to be in touch for other reasons. Now, if Alan Jackson would want to ask for an explanation, he could. But what Judge Cannone here does not allow Alan Jackson to say what I just said and says, no, Jennifer McCabe, you can go answer whatever you want and give any sort of explanation that you want, which again, I just don't think that that's really proper.
Thing more than me calling and saying, hey, did they come to your house? That's what we did when the media showed up, when Miss Reed's private investigator showed up. We just give each other the heads up, hey, somebody's coming, because we're just like normal moms. We're not used to this.
And that's why also you see how she's trying to make it to the jury. We're just normal moms. That's what she's trying to portray, which again, I said she's doing a lot better job this time than she did the first time. But that's also when you allow the witness, what the judge just did, allow the witness to talk about whatever they want. So then they can start adding all this extra information, which really takes away from your cross-examination. So it's really, again, like I can't reiterate it enough, but I just think it's not proper.
Helpful in making sure that the stories she tells are consistent with the stories you tell to different law enforcement agencies, correct?
No, we are not telling stories.
So let her finish. You said no what?
I said, no, we're not telling stories. We don't have to compare.
And if in fact what you were telling is just the truth, there would be no reason for you to inquire about who's contacted her when.
There's no inquiring. It's like when when the ice cream truck was at the street next door and I'm saying, did the ice cream truck come? It's really that simple.
So you asked a question,
Not an ice cream truck.
an argumentative question, and she responded in kind. Next question.
Thank you.
So again, we'll get another area where, what was the question that Alan Jackson asked? Alan Jackson asked, there would be no reason for you to talk to Carrie Roberts if you're just saying the truth. So that either the answer is, you're right, there is no reason, or the answer is no, there are reasons. If I want the reasons, I can ask you, but all the question asks for is, there is no reason, right? So the answer is yes or no. Instead, Judge Cannone allows her to talk about ice cream trucks. And then her explanation for that is, well, you asked an argumentative question, so she's answering in kind. No, she's not answering the question. It's not a responsive to my question. She's answering other questions that I didn't ask. I didn't ask for an explanation. I didn't ask to tell me about ice cream trucks or give me an example of what this is similar to. That's not what I asked. I asked, there's no other reason to speak to Carrie Roberts if you're just going to say the truth, right or wrong. That's it. Just answer the question, right or wrong. And if you say wrong, then I have the choice to say, well, why? And then you can tell me about your ice cream trucks. So again, we're seeing the same thing play out, which again, it's improper.
You also testified in your direct examination, staying with Ms. Roberts for just a second, about a timeline that you and Ms. Roberts put together, correct?
Yes.
That's another example of the two of you talking about your own perceptions and comparing and contrasting those perceptions and putting it down on paper, correct?
No,
Yes or no?
it's a no. Can I explain or no?
I'm sure Mr. Brennan will have follow-up questions.
Exactly. And that's how it's supposed to go. The answer is yes or no. Do you want me to explain? No, I'm sure Mr. Brennan will ask you for explanations. So that happens a lot of times. You can say, yeah, no, Mr. Brennan's going to ask you to explain it, and that's his choice. I don't need an explanation. That's how it should go.
After you gave that answer to those law enforcement officers at that separate law enforcement agency, they asked you, was there anyone else that you contacted in that 10-minute period before we got a chance to talk to you? And your answer was no, correct?
Correct.
And that was a lie, correct?
It wasn't a lie. No.
Was it true?
Watch what Alan Jackson here does, because this is just the difference between a good lawyer, a phenomenal trial lawyer, and someone who's not as good. Look how he frames this. He says, that was a lie, right? And she says, no, it wasn't a lie. Well, was it true? All right, you don't just take the answer and then you say, okay, well, how am I going to figure this out? Well, was it true or was it a lie? And you kind of are boxing the person in. Look what he does. It's really, it's a clinic for cross-examination. So watch what he does here. It's just amazing.
Was it the truth or a lie?
It wasn't a lie.
Okay, so it was the truth. You had not spoken to any other person between the time they contacted you telephonically and you said, I need 10 minutes, and then they came in the door. During that arc of time, you didn't talk to anybody else or contact anybody else other than Matt McCabe, Carrie Roberts. Now you're testifying that was a true statement. Yes or no? Yeah.
I can't answer that yes or no.
So pretty binary. Had you talked, well, let me ask you this. In point of fact, you did talk to other people. Did you contacted others in addition to Matt McCabe and Carrie Roberts, correct? Yes or no?
Yes, I did.
Okay. So when you said no to the answer, did you contact anyone other than Matt and Carrie? That would be, by definition, Ms. McCabe, a lie. Correct?
No.
It's not a lie? Is there some shade of lie that I'm not aware of?
It's the way you're asking the question. If
Okay,
I
let
could
me ask it a
explain,
different
if I could explain,
Let me ask it
it
a
will
different
make
way.
more sense to you.
You just see the way that he's setting this question up is just you have to say whether it's a truth or a lie. Was it a truth or a lie? I know you want to explain. I know you want to explain that you forgot about it, but at face value, what you said was untrue, was not the truth, which means that it was a lie. So the way that he's setting this up is just brilliant. This is how you cross-examine a witness.
The agents asked you, I'm going to go over this one more time, then I'm going to move on. The agents asked you, in fact, did you contact anyone between the time we called you and set up the interview and the 10 minutes before we walked in the door? They asked you that question, correct?
The objection sustained. Watch the choice of language.
I'm sorry. I meant the law enforcement agency. That law enforcement agency, the members of that law enforcement agency contacted you.
Mhm.
Sorry. They asked you who you had contacted between the time they first telephoned you and walked in the door 10 minutes later, correct?
Correct.
Okay. Data point number one. Data point number two, you told them Matt and Carrie, correct?
Correct.
You actually contacted, they then asked you, did you contact anyone else other than Matt and Carrie, correct?
Correct.
And you said no. Is that correct?
At that moment, I said no. Yes.
Correct. At any moment.
No, at that moment, because they had just come in my house.
I asked you,
Only one person can talk at a time.
you said the word no.
She was finishing her answer. Finish her answer.
I had said no.
And again, this is another instance. No, you don't get to finish your answer. You don't get to explain. That's not how cross-examination works. And you keep seeing this play out in the entire trial. It's really frustrating for a trial lawyer. And I'm telling you, Alan Jackson's very frustrated by this. He doesn't like this because this is not proper. What I think is proper. He probably doesn't feel it's proper either.
Because I was in a situation where there are two officers from a different agent had come in, were asking me questions, or they had said, can I come in and ask you questions? At first, I thought they were selling something. Then they identified themselves. I just dropped my kids off at school. Going to be completely honest. I hadn't brushed my teeth. So I kind of made some phone
Objection, Your Honor.
calls.
This is
That-
unresponsive.
So next questions.
Thank you. Ms. McCabe,
Mhm.
after you said,
So he finally was able to actually get the judge. Okay, now come on. Even you would agree that this is just not responsive. And then she finally agrees with him. Let's move on.
no, that you hadn't contacted anybody else,
Mhm.
those two law enforcement officers from that separate agency who had told you it was a crime to lie to them, they left, correct?
Yes.
Subsequent to that, Mr. McCabe, your husband,
Objection.
Sustained.
Now, what happened here is that her husband told her, oh, yeah, you did forget to tell them about something. So the objection here to me sounds like it's hearsay. Now, hearsay, you are allowed, and the way that I would definitely argue this is that I'm not offering the hearsay for the truth of the matter serves. I'm offering the hearsay because I want to see what her action was because of those comments. I don't care about the actual comments, whether they're true or not. I want to see what action she took because of that hearsay. So it definitely could be an argument that she would be allowed to say what Matt told her if that prompted her to do something. But anyway, let's continue.
they left you their card so you could call them if need be, correct?
Yes, they did.
And you, in fact, did call them back, correct?
Yes, I did.
Without telling me the content of the conversation you had, did you have a conversation with Mr. McCabe?
Objection.
Sustained.
Did you call them back and say, I'm calling you back because my husband told me
Objection.
that I lied to you and I better clear that lie up?
So sustained. Jurors, remember I told you before that only answers to questions are evidence? Be mindful of that.
They were
Next, yes.
So again, this is also something I mentioned in yesterday's video where you have the judge instructing the jury to essentially disregard the statements that Alan Jackson was saying, reminding them of this jury instruction that questions that the attorneys ask and the comments that they make are not evidence. Even though he's trying to bring out the point that she was not 100% truthful to the investigators. Now, what gets even a little bit worse for her as this goes on is the fact that it wasn't just like one person that she forgot about. That's maybe a little bit more excusable. I told the federal agents about, 10 different people that I spoke to, and I forgot to mention one. Okay, people forget. She just mentioned 2 people. And this also just literally happened, 20, 30 minutes ago, right? She said it was a very brief meeting with the federal agents, and she just needed 10 minutes before to get ready for that half-hour meeting, right? So it was a brief meeting, and that's what she just needed. She just needed those 10 minutes. Now, what's very interesting is that she forgot to mention a few people. She forgot to mention Peggy O'Keefe. She forgot to mention the witness advocate, and she also forgot to mention Brian Albert. So it's like you told them about 2 people, and you forgot about 3. And that's what's going to come out. And that's, again, very compelling. It doesn't look great for Jennifer McCabe. It looks like she was trying to hide that information. And then her husband, Matt McCabe, said, you shouldn't hide that information. You should probably call them back and tell them that you spoke to those other 3 people also. After all, it's a crime to lie even in this interview. So that's what the rest of this this line of cross-examination brings out. Let's move ahead a little bit to here, which is we're talking about Chloe here. And I think Chloe is one of the most important parts of this case, I think. And the fact that there was no reaction from Chloe, despite everything going on outside of the house, and then Jennifer McCabe bursting into the room. So let's listen to how he sets this up. And again, the way that he frames it, the way that he sets this all up is really brilliant. It's really good.
Brian Albert and his family had a dog on January 29th, 2022. Did they not?
Yes, they did.
What was that dog's name?
Chloe,
What kind of dog was Chloe?
German Shepherd.
Was it do you know if it was a purebred German Shepherd or a mix of Malinois and German Shepherd, or do you know?
I have no idea.
Big dog,
Yeah, good sized dog. Yeah.
70-pounder.
I don't know its weight.
Wasn't a little munchkin dog, though. It was a full-size German
It's a
Shepherd.
full size. Yeah.
On the morning that you described going into the house, January 29th, 6:40 a.m. or so, you indicated that you burst into the bedroom to wake your sister and Brian Albert. Is that right?
Yes, I went into the bedroom.
Now, you notice this time around, she also kind of tried to change that whole bursting into the bedroom. And that's what she testified in the first trial, or it definitely came out in the first trial, that she burst into the bedroom. And now she's trying to calm that down a little bit.
It's still dark out, correct?
Yes.
There had been relative chaos on the lawn for a number of minutes, from about 6:10 until at least 6:40. We went in, there were still emergency vehicles with lights on and engines running. Chaos, relative chaos, bedlam, as somebody had said, on that front lawn, correct?
It was more on their side lawn and down the street, kind of like all the cruises. A lot of them were behind their lot.
Right in front.
And that's really, really not going to work. I mean, it's really not going to work. She knows where he's going with this. Chloe, this dog, and all this chaos and bedlam in the front yard. And she's trying to say, well, it was a little bit more down the street. I mean, come on. It was still within plenty of view of the bedroom window. You can even see them from the police cruiser, from the dash cams. That argument's not going to work. So I know she's trying to do that, but it's really, I don't think that's going to work on the jury at all.
34 feet, correct?
To the side, in the side yard of 34 Fairview, yes.
And on the lawn of 34 feet,
Yes,
where first responders were responding, correct?
yes,
You said my client was screaming to the top of her lungs, is that right?
yes, she was.
And Kerry Roberts was screaming back at her.
Yes,
Shut up or shut the fuck up, right?
yes,
Then at 6:40 a.m., under the cover of darkness, you walked in the unlocked front door of Brian Albert's house, correct?
I went into my sister's house, correct?
And notice the details, the unlocked front door that he's adding, and he's just painting the picture. He's painting the picture of everything going on. It's like a storytelling. It's part of what a good trial lawyer does. He's able to storytell, and then he's walking her through this scenario, and the jury's listening to this, and then where's the dog? After all that, you're painting this whole story. What happened to the dog?
It wasn't Brian Albert's house?
And Brian Albert, yes, I'm sorry.
You then climbed the stairs up toward the bedrooms, correct?
Yes,
You walked into the bedroom door where Brian Albert and Nicole Albert, according to you, were sleeping. Is that right?
yes,
So you would agree that you
Like how he said, according to you, we're sleeping, even though, again, it's just hard to believe that they were sleeping through everything. But again, according to you, going into your view, they were sleeping.
unexpectedly in terms of their view, unexpectedly walked into their house basically in the middle of the night, middle of the morning.
Yes.
You indicated that when you went through their bedroom door, you sort of burst through, correct?
I opened the door. I don't know if I used the word burst.
You previously indicated that when you went through the door, it was chaotic because you were so amped up from the events. Is that right?
I don't know if I used those words.
Would you say that you were loud or quiet?
I think as I explained earlier, I was like where everything was going on around me. And I was kind of like in just a state of shock. And I remember thinking, I don't want to startle them, but I have to wake them up because obviously when I wake them up, they're going to be panicked and think something terrible happened.
Well, why didn't you want to startle them? Something terrible had happened.
I didn't want to give them a heart attack when I woke them up.
But you didn't walk up and just nudge them and say, hey, Nicole, honey, can you wake up or something? You didn't do that.
No, I was like, Brian, Nicole, wake up, wake up.
Okay, exactly. But you weren't saying it in that voice either. You were saying, Brian, Nicole, get up.
I'm not sure if it was that loud, but I definitely was. You definitely like trying to wake them up. Yes.
What was the dog's reaction?
I don't recall seeing the dog.
So,
And that is just one of the biggest questions in this case. When you have all this action in the front lawn, and Jennifer McCabe walks into the house, a dark house, alone at night, and creeps up the stairs, and she's not going like, she's not going to be going like quietly up the stairs and just slowly knocking on the door. Obviously, she's going to be coming in a little bit frantic, right? So, I mean, that's what you would expect, and no recollection at all of any dog being anywhere. No barking, no nothing. Where in the world is Chloe? So that's also just a great point Alan Jackson bringing out on cross-examination. So now let's move on, excuse me, to a little bit more further on, where he's talking about how Jennifer McCabe was able to see the tire tracks. She testified about being able to see tire tracks, even though she wasn't looking for tire tracks. And that's going to be an important part. She's looking at the car and she notices in her peripheral vision tire tracks around. So he's developing this idea that you see not just directly what you're looking at, you also see other things. And in fact, you remember in specific detail about those tire tracks. And how come he's going to be building up when you looked out at the house later and you looked out of the house and you did not see any sort of vehicle there, right? That was her testimony. The vehicle was gone already. You didn't notice John O'Keefe lying in the front yard, even though you looked directly into that direction. So the way that he compares and shows how you did see the tire tracks, again, this is just great cross-examination. You're showing how this witness does see well in the peripheral vision. She's testified to that. But then when it comes to seeing a 6'2", 216-pound man lying almost basically in the front of her vision, she does not see that at all. So let's start with the dog here. Let's start with the tire tracks. Just pull it up to right here.
you also previously indicated that you saw tire tracks in the roadway.
Yes.
In that very, very light dusting of snow, the accumulation that you talked about, you saw tire tracks of some sort.
Yes.
So that's down on the ground, beyond the yard, somewhere in the roadway.
In the street, correct.
You had a good view of those tire tracks as well, correct?
Yes.
As a matter of fact, you were able to describe those as sort of almost a wave, I think you once said.
Yeah, across the street. I could see it because of the street light. That was.
So you see, describing it, she's able to see it, but now she's, oh yeah, well, there's a street light there, and she's going to try to say that there's a difference between having a street light and when it's very dark. But you know, we're going to get to that because he's wearing all dark, and there's a white dusting of snow on the ground. I mean, that would also pretty much stick out. So he's bringing out, you see it in pretty good detail, the tail lights. But then all of a sudden, when it comes to this, we're going to see right here, all of a sudden, you don't really have such good peripheral vision anymore. So let's pull it up here. Let's get the right spot. Give me 1 second to get it there. Here we go.
I didn't see him.
And the last time you looked out, Ms. McCabe, this is now 12:45 or so. The last time you looked out, the SUV was gone. Is that right?
Yes.
But you were still looking in that direction because that's the last place you saw the SUV. Is that right?
I looked out the window like this. I wasn't searching anywhere, but just glanced out the window, and I didn't see it.
I'm just asking you a direction. Not whether or not you were searching. I know you didn't sit down search party. That's not my question. My question is, when you're looking toward the area where you last saw the SUV around 12:45 a.m.,
Yes.
that would be directly across the lawn, directly past the flagpole, and directly into the street where you last saw the SUV, correct?
I glanced out. Yes, correct.
And the same way you glanced out at the SUV, to use your words, glanced out and saw the tire tracks, right?
Correct. Yes.
But you did not see John O'Keefe standing on the lawn.
No,
You did not see him sitting on the lawn,
no,
and you certainly did not see his body lying on the lawn, did you?
no, I did not.
See, you see how he put the two right next to each other. It's the same way you looked out and you saw those trolley tracks, but you didn't see John O'Keefe's body when you looked out that time either. So again, just a great way to cross-examine a witness. So let's finally get to the last part, which may have been even the biggest highlight of the cross-examination, and that is when it comes to where she's saying that she definitely heard him say, I hit him, I heard Karen Reed saying, I hit him, and let's see what he does with this. So again, great job here, and it's great to see some good lawyering here. Nice to show to everybody. So let's take a look.
You claimed on direct examination today, as a matter of fact, that Miss Reed looked at you at the scene and said the phrase, I hit him, I hit him, I hit him. She said it 3 times very distinctly, according to your testimony, correct?
She did, yes.
That was so impactful that it had the effect of putting you in some sort of shock and horror. Is that right?
I was in shock the whole morning, but that statement definitely was a lot.
And that's an incredibly memorable statement for you to have heard and now recount to us in this trial, correct?
Look how he builds this up. It's such an incredibly memorable statement that she made, right? He's going to build this up so well that it's going to almost be so unbelievable that she would ever leave it out, ever, in any statement or any grand jury. And just the way that he builds it up is brilliant.
Correct.
Something that you wouldn't easily forget or overlook. Is that right?
Something I wouldn't.
Something you would not easily
Correct.
forget or overlook. Is that right?
Correct, yes.
Matter of fact, some might say it's the centerpiece of your testimony.
Objection.
Sustained.
You wouldn't forget it. You wouldn't overlook it. It's so memorable.
Ms. McCabe, you testified at a grand jury in April of 2022, did you not?
I did, yes.
Before you testified, you took an oath, very much like the oath that you took before you testified in this case, correct?
Correct.
You swore to tell the truth, the whole truth, and nothing but the truth, so help you God, correct?
Correct.
And that included the whole truth at the state grand jury, correct?
Correct.
That was only weeks, several weeks, but weeks after this incident.
And look, this is all buildup. I mean, he could have just said right away, you didn't say this in the grand jury transcript. And I know a lot of lawyers maybe do that because they want to get to that fact so fast. They want to get to this gotcha moment so fast. But he's much more patient. It's more patience. It's more building it up so that when it actually comes, when it's dropped on the jury, it's so much more impactful. It's so much more powerful when he builds it up this way and letting the jury think, where is he going with this? Where is he going with this? Instead of just saying, you know, something that you never forget, right? Well, you did forget about in the grand jury, right? So like, that's just so fast. But here he's just building it up in anticipation. Everyone's anticipating, what's he going to do? And then he drops it on her. And the way that he does it, I mean, some people are saying this is theater. This is not theater. This is cross-examination. This is how you effectively cross-examine a witness. Okay, so if some theater is involved, then that's necessary. And if you want to do a good job. But just watch how he just builds this up. And this is how you do it. This is just exactly how you do cross-examination.
Right? April 26th versus January 29th, 2022. Is that right?
Correct, yes.
Things were much fresher in your mind then than they are now.
I wouldn't necessarily say that.
Especially something as momentous as an admission from my client that she hit him. Would you agree?
Would I agree that she said that?
Would you agree that that would be fresh in your mind? Something as momentous as that. You wouldn't forget that.
I will never forget it.
You wouldn't overlook that.
I will never forget it.
You would not overlook that either, would you, Ms. McCabe?
I answer the questions I'm asked.
Can you answer the question that I just asked? You're not answer my question. Would you overlook that?
No.
And the reason you wouldn't overlook it is because it was so impactful on you, having heard that. Not once, not twice, 3 times. I hit him, I hit him, I hit him. Is that right?
Yes.
I mean, the suspense that he's creating here, the anticipation on the jury, I mean, it's just masterful. I mean, there's nothing more to say about it. It's just really just great. And he's getting her to admit this. Yes, it's so impactful. It's something I would never forget. I would always say it. Yeah, no. And he's just getting her to admit it all. And then he's going to drop it on her. It's just It's really good.
May I approach?
Yes.
Thank you.
Take a look at that document. Tell me if you recognize it.
Yes, I see it.
Is that a transcript of your entire testimony at the grand jury in April of 2022?
I believe so, yes.
You've reviewed it in the past?
I have read it about a year ago, yes.
You read it in anticipation of your testimony a year ago, correct?
Yes, I reviewed it.
Have you reviewed it in preparation for your testimony today?
No, I haven't.
Yesterday. Ms. McCabe, turn to the page or pages in that transcript where you recount to the grand jurors that my client said, I hit him, I hit him, I hit him.
This is over 227 pages.
Take your time.
How long?
You see, just the way that he does that, like, here, go ahead, show me where it says it. Instead of saying what he wants to say, which is how many attorneys would do this, just saying, Jennifer McCabe, you never said that in the grand jury transcript, did you? Instead of just saying that, he does this. He drops the transcript and it says, here, go ahead, find me where you said that. Find me where you said that. And she can't find it because she never did say it. So it's all part of building this up. And it's just a way in the presentation of showing it to the jury. And yeah, of course, there's going to be objection. Of course, he's not going to be able to do it, but it doesn't matter. The point is just so powerful and it's made, and it's really should be well taken by the jury. So this is just masterful. It's great cross-examination by Ellen Jackson. Again, I don't want to take anything away from Jennifer McCabe this time. She definitely herself did a much better job testifying, but Alan Jackson's Alan Jackson. So, I mean, he's just a beast in there. I mean, the way that he conducted this cross-examination, I think, was incredibly effective. Some lawyers were texting me while I was watching this trial, and they were seeing some snippets and letting me know about their opinion was how Alan Jackson was doing such a great job, and that's what it is. I mean, this is what you come to expect from these really good high-profile attorneys. So I just wanted to show you that all today. So that's going to be it for today. We will see you all here tomorrow for the live stream. And hopefully, again, of course, we'll keep our recaps coming, keep our analysis coming. If you haven't yet, please subscribe and like, and we will see you next time.